All right, good afternoon, everyone, and welcome to today's webinar. My name is Jorge Acosta Palmera, and I'm the director of the Statewide Training Initiative with Florida Legal Services. We're excited to have you join us for the Supreme Court's TPS decision, what it means for the Haitian and Syrian communities. Before I introduce our speaker, I do want to go through some quick housekeeping announcements. This training is being recorded. I know it's at 3 p.m., it's not the usual noontime webinar, so if you registered for it, you're going to receive a copy of the recording. We will also be posting it on YouTube. So you should be able to find that on our YouTube channel as well. So the training was approved by the Florida Bar for one general CLE credit, one state and federal government and admin practice certification credits, and one immigration and nationality law certification credits. I'll announce the CLE code towards the end of the webinar. I will also drop it in the chat, and that CLE code will also be going out via email from Zoom with the recording. And I may also make sure to include it in the YouTube description, which you can expand and find more information as well. Closed captions are enabled for anybody who needs them. So if you're having any issues with accessibility, feel free to let me know directly or via email. The training is being co-hosted by the Public Interest Law section of the Florida Bar or PILS. So if you're not familiar with PILS, I highly encourage you to take a look at their website. We have one particular working group, the Civil Rights and Immigration Working Group. It's like one of the most active ones. So they meet every month and they always have great meetings and great training. So I highly encourage you to take a look at PILS. And final piece of housekeeping announcements are questions and answers. If you have questions, this session is going to be a little bit more interactive. So feel free to use the Q&A feature. That way our speakers can either try to answer the questions directly, or I can make sure to read the question out loud for the benefit of the audience so it can be addressed. So before we pass it over to our main speaker, I'm going to pass it over to my great colleague, Anne Piervil, with Florida Legal Services. And the floor is yours.
Thank you and good afternoon. So I'm Ann Piervil here with Florida Legal Services. It is my pleasure to introduce our speaker today, Deborah Saint-Vil with Catholic Charities Legal Services, here to give us an overview on the U.S. Supreme Court decision when it comes to TPS for Haiti and our Syrian population. So, Deborah, I'm going to hand it over to you. Please feel free to ask any questions. Let us know if you have any hot topics in the Q&A, and we'll be checking it and answering it. Thank you.
Thank you very much, George and Anne, and it's a pleasure to be here with everyone today. As Anne mentioned, I am an attorney, a managing attorney here at Catholic Legal Services, and I focus a lot on cases, especially TPS cases. And as she mentioned, if you have any question, feel free to type it in the chat. I like interactive Q&A, so definitely as you ask in the question, and you can interrupt anytime that you want, so we can try to answer these questions as we go. So I guess just a little background and gymnastic of what is TPS, right? And how did it end up in the Supreme Court in general? So TPS is temporary protected status for individuals that are not aware. And Congress had placed it that where the Department of Homeland Security can designate TPS for a certain country who individuals or the nationals in which are in the United States cannot go back for a period of time. But it's not just that they can choose to designate TPS, they have to be particular reason why a country have been designated for TPS. So it is two things. They look at the climate, the government climate, right? And they also look at whether there have been any type of natural disasters. So these are the two things that they look at to designate TPS. And both TPS was designated for Syria. I believe Syria was for the what was happening politically in the country, and for Haiti. And for Haiti, it was initially because of natural disaster, the earthquake in 2010, but it was redesignated in 2021, 22, and 24 for the political climate and the government structure that was causing a lot of issue in the country. And it have been placed. So 60 days before TPS ends, the Department of Homeland Security have the right to state whether or not they are going to renew TPS or not for this particular country. And what happened is Congress did give instruction on how they should extend, whether they should extend it or not, like the step that they need to take. Reviewing whatever the issue was or whatever the reason was that this country was designated to have TPS, they should review it to see if this issue is still in the country and still women at the country, to see whether they're going to extend it. They have a choice to extend it for 6 months, 12 months, or 18 months. And in the case of both countries, after within the 60 days to whether or not they're going to extend TPS, they decided to terminate TPS. TPS for Syria was terminated 60 days after September 2025. So that jumped to November. I apologize. Yeah, about November of 2025. And for Haiti, it was February 3rd, 2026. So they decided to end both country TPS. And both cases were called to the district court because practitioners did not believe that it was the proper decision and it was not done properly as well. That was the arguments. And also there was argument that this decision were based on race and not really based on what was currently happening in the country. Not to go fully into details of what happened into the lower court. Both courts put a injunction to whether or not the department could begin deporting individuals while they were still litigating the case. So both cases were being litigated in the appellate court right now, and the final decision have not been made. So the Department of Homeland Security took it in front of the Supreme Court for certiorari decision before for the judgment of whether or not they can begin deporting individuals. So this is how it ended up in front of the court back in, I don't recall the month. About 2 months ago, if I'm not mistaken. Yes, about 2 months ago. So the court decided that they were going to hear both cases together, and both parties made the argument. What did the court decide when it comes to TPS? They did not make a decision as to whether or not TPS should end, whether or not the Department of Homeland Security ended properly. They actually decided, the Supreme Court actually reversed the lower court order that paused the termination of TPS Haiti, right? And also reversed the lower court decision refusing, putting a stay on TPS Haiti, which now this is why a lot of Haitian who had TPS is in a limbo state, because the court stated that the circuit, the lower court cannot, I apologize, the district court cannot decide whether or not TPS should end, because that was not Congress' intention. Congress' intention was not for the judge to decide those things. It had fully left it up to the Department of Homeland Security. So it's similar to the Syrian case. The court, they were arguing, the argument was also administratively based, right? The procedure, whether or not the procedure were followed, whether or not DHS followed it, and whether or not they did the right thing in terminating TPS. And again, the court state that the judge do not have that right, per se, to determine whether or not DHS can terminate TPS. That was not Congress' intention when they gave the power to DHS to grant TPS. So I guess I kind of summarize it in a way. And both countries are now in limbo. Technically, a lot of people like to say, well, is TPS ended? Have it not ended? So really there's not a decision about that. So yes, the department terminated. So it's being litigated. But only the department can extend it. Only the department can decide whether or not they should TPS should continue, right? So this is why right now we are seeing 10 days extension, 14 days extension, because only the department's able to do it. So because the Supreme Court lifted the lower court decision as to the stay, which had allowed individuals with TPS during the time of the litigation to remain safe, to still remain with status. So I think that's kind of where I'll stop. And I know that's very short. And for me to open the door to questions so we can discuss it a little more.
I don't see any questions, but I have a question. So, with this opinion from the Supreme Court, who is affected by this? Because I know there's a lot of confusion. Is this everyone that already had TPS? Is this anyone that has the current TPS? Is this everyone from those two countries? Who's affected by this decision?
That's a great question. Definitely, it's everyone, right? So initially, the decision that was made by Judge Reyes, she stated that everyone was protected, whether you had TPS or whether your TPS application was still pending and you were eligible for it. So many of you are not aware that because TPS was redesignated in 2024. Am
Yeah.
I right? Yes, in 2024, the a lot of application was not adjudicated. So therefore, a lot of people had pending application for the past year and a half, almost 2 years for some individuals. So these individuals, according to Judge Reyes' decision, were all protected. So even if you had initially applied for TPS initially, but have not received a decision yet, but you were eligible for it, you would have been protected. So a lot of individuals like to think there was many TPS. When we talk about Haiti TPS, there have been a lot of redesignation for Haiti. There have been four different five actually different redesignation for Haiti. So TPS 2010, 2011, 2021, 2022, and 2024. So TPS was redesignated four different times after the initial TPS for different reasons. And based on that, the last TPS redesignation, which was for June 3rd, 2024, all the TPS kind of mashed up together and became one. So it was everyone should have had that last TPS. The To back up a little, the initial TPS in 2010 and 11 was also in litigation at a point. So it kind of became mute and then kind of integrated into the new TPS that was redesignated back in 22 and 24. So therefore, all these individuals are affected. So there are about, the number says 600,000 people eligible, but there was 350,000 that currently have TPS. So you could imagine there was a couple hundred, well, at least 150 thousand that was eligible but have not received a decision yet as to whether or not the TPS application was granted. So all these individuals are essentially affected today.
Okay.
We do have two questions in the chat. The first one is, what are the legal options for those who had TPS for over 20 years?
Okay, so that is a great question. So, what we do tell individual when it comes to immigration, it's not a. I've been in the United States for many years, and I could be eligible for relief. It doesn't work that way. We do have relief, different ways for someone to adjust the status, but they have to be eligible for it. And it's not based on how long you've been in the United States. So the first way someone can adjust the status into a permanent resident is through family petition. So your spouse, U.S. citizen spouse, or legal permanent resident spouse can petition for you. So that's one way. Your U.S. citizen children can petition for you, but they have to be 21 or older. So I know you mentioned 20 years, but a lot of time, a lot of TPS holders have children. And once that child that is a U.S. citizen that's born on the soil. So once that child turns 21, they are able to petition for the parents. Your sibling can also petition for you. They have to be a U.S. citizen. However, that process takes a very long time. Last time I checked, it's looking about 12 years to 13 years before it finalized and you actually able to adjust your status. And your parents can also petition for you, whether your parents is a legal permanent resident or you a citizen. And again, it also the process length, it depends whether you are a minor under the age of 21 or if you're above the age of 21. And secondly is whether or not you are married. So there are a lot of little nuance with it, but a family can petition for you, a family member, and it's limited to spouse that are legal permanent resident or U.S. citizen, parents that are legal permanent residents or U.S. citizen, your child have to be 21 years old and a U.S. citizen, and your siblings have to be a U.S. citizen. So that is the family-based way of you being able to adjust in the United States if you qualify. And I'm not going into all the element and all the details because they have some. And when it comes to employment base, your employer can petition for you as well, right? So, and you can also do self petition and the other petition based on talents, right? So, those are more business based immigration. And again, I know I'm saying it very loosely, but it is very difficult. And it does cost a lot of money, and you have to show there have been a lot of restriction with those two in the past years regarding the employment base and how much money that you are actually bringing in employment based or business based in the United States. So those are the petition. We also have humanitarian based visas, which are self petition visas. So one of them that a lot of people are aware of is called VAWA. This is Violence Against Women Act. So you have to be married to either a U.S. citizen or a legal permanent resident. And that individual, you have to be a victim of pretty much domestic abuse for you to be qualified for the self-petition VAWA, which is a humanitarian-based visa. We also have what we call the U visa or T visa. So a U visa is you are a victim again of a crime. It could be domestic, and it happened in the United States, but it doesn't have to be from a U.S. citizen. So the INA, which is the immigration law, it have a list of crime that qualifies you to become self-petition. So, for example, it is not all crimes that you suffer or become a victim of that allows you to self-petition and do a U visa. And there's a caveat as well. The either the state attorney or the police department have to sign off on it that you have been a witness or you help with the investigation. So if this individual was a victim or was a witness to a crime, but never actually helped, the police department, the sheriff department, or the state attorney most likely will not sign it because you were not helpful towards that investigation. And lastly, we have what we call a T visa, which is you are a victim of traffic, and it could either be employment traffic or sexual traffic. These are the two trafficking that they allow you to self-petition as a T visa. So these are the humanitarian base visas that can lead you to adjust your status. There are other humanitarian based visas that are not permanent, that are also similar to TPS, but it's temporary for a specific needs. But again, these individuals have to be qualified, so they cannot simply choose to, I can't stay in the United States, or I want to stay in the United States and I want to adjust my status, and they'll just figure it out. It doesn't work that way. You have to be qualified for one of those. There are demands in front of the judge that individual can ask that have been residing in the United States for 10 up to 20 years or even more. We do have one relief that is called a non-LPR cancellation, and that's when you are placed in removal proceedings. You are in front of the judge, and this is a relief or a demand that you can ask for, again, if you qualify for it. What's important is that you should not have been in removal proceedings at all within the first 10 years that you've been in the United States. So, for example, someone who has been here on TPS for the past 16 years, but had a removal order in the early 90s or early 2000, or for similar to Syria, early 2000, if they already had a removal order, but later qualified for TPS, this individual will not be qualified for a non-LPR cancellation because you will need to have never been placed in removal proceedings. And not only that, now you have to also show that you are of a good moral character, and you also have to show that you have a qualified relative that will have an extraordinary hardship if you were to be removed from the United States. And this qualified relative must be either a parent or a spouse. And a lot of time, people or individual will think that minor children will qualify you for it, but unfortunately, they don't. It really have to, like, it could be an extra, I guess, thing that you tell the judge, right? But the qualified relative should be a legal permanent parent or U.S. citizen, or legal permanent spouse or a U.S. citizen spouse. So these are some of the relief that you could ask that people could be qualified for when it comes to other options. Some people, fortunately, are eligible for other ways to adjust the status. We see it all the time where they have children that are 20, 30, but because they had CPS and they do have a work authorization and they're able to build a life, many people have not, I know, for lack of a better word, have been complacent for many years and have not found another way to adjust. And we realize that they are eligible. There are people that are married. There are people that the employers have decided to sponsor for them, and they can sponsor for them. So there are many people that are eligible for other relief, but there are also a lot of individuals that do not have any relief available for them because they do not qualify for any other relief at the moment.
Thank you. There's another question.
Yes.
Is there any hope for TPS to be extended based on other lawsuits? Are there any other lawsuits pending?
Right now, I think that is the lawsuit pending with TPS currently, is the one in front of Judge Reyes. Um, and that's what, but that is a lawsuit still pending, viable right now. But we still, there is a discharge petition, which is now Bill S 4814, that is currently in front of the United States Senate. So that is another pathway that I'm aware that advocates have been looking into for another type of hope instead of in front of the courtroom, because as I explained earlier, the court literally remove the power of the judge when it comes to whether or not there should dictate if one should extend TPS or not. So I don't see any extension to the judicial pathways because according to the Supreme Court, that's not what Congress intended. But with Bill S 4814, it already passed obviously to the House. They voted yes. That is another way to extend TPS for the next 3 years, and that's only for TPS Haiti right now, not any other TPS. And so we're looking to see whether or not it's going to be extended. Well, passed through the Senate. So it have not gone yet to a vote to the Senate. So this is the only other pathway that I am aware of right now that we are paying close attention to when it comes to TPS. I mean, this is a silly, and not to give my opinion. I don't know. I don't foresee any type of extension for TPS right now for the countries in which they had decided that they want to terminate TPS for.
I'm looking at the chat and the Q&A. I don't see any other pending. Keep them coming if anybody has additional questions. I did want to ask about like timing wise, when should we expect the actual ruling to like go into effect? How much time should people expect to have to take action?
Okay, so we can talk about the timing. Um, Unfortunately, I can't tell you a timing right now. Initially, so if we look at history, when TPS, again, this is not the first time that TPS is under attack, right? So in the first TPS was intended to be terminated back in 2017, and each time that the deadline was coming, they would extend it for another 18 months or 12 months. So the court will extend it, a new federal registry will come out and saying that, okay, litigation is still going on, whether or not they should terminate TPS. And because this litigation is still going on, your TPS will be automatic. And it was a reasonable timing. If I'm not mistaken, it was between a year or 18 months. It was, they gave the full amount of time. And the Federal Register stated if a decision comes in before this time, then that's when they'll decide whether, if the decision comes, whether or not TPS will terminate before the time, the extension they have given, then it will terminate. But if it does not, then 60 days prior, again, they used to renew it. And that went on for about 4 years. So a lot of people had assumed the same thing would have happened, but we have seen with TPS Venezuela and other TPS, when it ended, they automatically ended these individual benefits. And even though they were in litigation, there were no proper extension that was being done. And they took it to the Supreme Court, and the Supreme Court again always sided with the department, and the department choose when and how long that they're going to give an extension for. And as we've been seeing, they give one for 10 days, another one for 14. So we're not sure how long this is going to continue for, but we can't predict it either because the sole discretion remain with the department while litigation is still going. So therefore, that's not something that we can estimate. But and this is why we have been trying to educate individuals and also other attorneys. It is time to prepare right? Because unfortunately, if you are someone with TPS, you could be detained and you could be deported if you already had a final removal order. As I mentioned, there's other people who had removal order before they became eligible for TPS. So we are telling individuals to prepare right now as if it's going to end tomorrow. So if you do have properties, people who's been here for 20 years, 15 years, that have purchased property, we are telling them to speak to wills and trust and estate planning attorneys, real estate attorneys, so they can kind of see how they can redistribute or put in power of attorneys so they can be ready. For individuals who have minor children, especially if they are U.S. citizens, because that is not a way for you to remain in the United States. And a lot of individual assumes that because you have a minor U.S. citizen child, you'll be protected from deportation or to be removed from the United States. Unfortunately, it doesn't work that way. So we are encouraging individuals that do have minor children to prepare and plan properly, whether it is power of attorney for your minor child, whether it is healthcare surrogate that need to be done for your minor child, or nomination of guardianship. We are telling parents to get these things done, because what you don't want to happen is for you to be detained and your minor child and no one else know what to do with your child because you didn't prepare properly, and this child end up in the foster care system when it could have been avoided. And even if it's a fortnight or a month, if you had those things put in place, that child will probably not have to go through that. So we are telling individual to get ready because of the new laws and the police and sheriff department being deputized as ICE agent. And if you cannot show your document as any time that you've been stopped, then the detention rate have been extremely high. Individual constantly being detained while driving. So therefore, a lot of people are unprepared. People are getting detained on their way to pick up the children. So we are asking them to get those things ready just so because the inevitable, we don't know what's going to happen, and it's the truth. And we don't know when you're going to get detained. And even if you have TPS, so what we've seen in individual who have TPS, they come in, they come in, they get detained, and depending on who is the ICE officer, they might release them, and depending on which county they are, they don't release them. So therefore, we cannot predict what's going to happen. Everyone kind of see it differently. So it's about being prepared, and that's the best we can say to individuals right now. Even with employers, and we know it's not fair to tell employers to wait, but that is essentially what have to be done, because especially in the healthcare system and hospitals, the dates of renewals are so short and unpredictable. A lot of employers are asking, well, what should I do? I have a full staff that with individual TPS, and what we're seeing is whether or not you want to take the risk of waiting every 10 or 14 days to whether or not it's going to be extending for another 10 or 14 days. So we know it's a very difficult moment. They are in a limbo, but there's not much that could be said beyond getting ready and preparing yourself properly, and consult with an attorney, immigration attorney, and estate planning attorney, so you can see your options.
Thank you. There's one more question in the chat. I'm going to read it out loud. The question is, are there any medical exceptions, avenues for self-petition?
Okay, so we have so there's not a medical exception avenue, but there is a what we call deferred action. And as I mentioned earlier, that was one of the humanitarian base, but it's not an adjustment. it's not a self petition, and it is an extreme hardship to a U.S. citizen, and you as the TPS holder or the non-U.S. citizen are requesting to remain in the United States for a period of time because you are the caretaker or because this U.S. citizen individual is gonna go through hardship if you were to be removed. So we've seen it in case where the minor child is extremely sick and the parents have to remain in the United States. So you'll do what we call a deferred action. Or where is the parent, an elderly parent who need the care of the child, who is an adult TPS holder, obviously, and so we requesting a deferred action. So the extreme hardship have to be to the individual that is a U.S. citizen, and the TPS holder is requesting to remain to a deferred actions in the United States. So as I mentioned, it's similar to TPS because it is temporary. It doesn't give you full access to or a pathway to adjusting your status. It simply allow you to remain in the United States and allow you to request a work authorization card so you will able to work lawfully in the country.
All right, thank you. I don't see any other pending questions right now. I mean, I know there's one question that will come up. You mentioned making sure people are prepared, estate planning, talking to an immigration attorney. Some of the legal aid organizations may have restrictions on who they serve, and they may not necessarily be able to help somebody who's on TPS status. So, if from an advocacy and outreach perspective, do you have any tips or recommendations, making sure that there's no misinformation? What resources are reliable, any tips or any direction that the legal aid community could provide to other community partners and to people who may need legal assistance?
Definitely. As far as yes, of course, because of the restriction with TPS, um, there are what we try to do because of that is a lot of pro bono services and maybe encourage other attorneys because so many attorneys are asking how can they help, and and that's the best way to help, right? Because obviously with the legal services we are restricted or grants are restricted a lot to whom we could serve, and with pro bono attorneys they're not restricted to who they can serve. So having that pro bono will for in the pro bono will of attorneys who's willing to help individual who currently don't have no status to help them with those type of services would be definitely great. And I think that's the most that could be done in the sense. So and also training attorneys. A lot of attorneys are not familiar with this type of law, right? But they want to help. So I think putting on trainings regarding those services, and it is a lack of definitely, especially for power of attorney, and it's simple, but it's a lack of that. Not that many individuals know how to do it. So if providing those trainings and putting on those trainings for these individuals could be very helpful because you'll be able to still continue helping individual even if it's not in your office or through your particular grant, but because you are training other attorneys to do those things pro bono, I think you're still doing the best work that you could do when it comes to individual that have TPS right now.
So, Deborah, I know a common question that a lot of TPS holders have been asking is, I had a removal order and I also applied for asylum. I got TPS, they closed my case. So now I have no case. What's next if this TPS ends? What happened to that asylum case?
Okay, so that's a great question, and I think that's a question that could also help. A lot of people have TPS, or but they also have other status pending. So which I briefly mentioned earlier, uh, so, for example, if you had an asylum pending and you terminated that case because you had TPS, then you can actually reapply based on where you initially had applied, right? So a lot of individuals had terminated in court. So if they did, we tell them to reapply with the USCIS or with the asylum office, because they still have that right, because they still, in a sense, you can still argue that they preserved their 1 year if they had filed before the 1 year deadline. So one way to answer your question, I'm going to pivot back to George's question earlier about um the legal services possibly not able to help a lot of individuals with temporary protected status, but I do know that they're usually able to help people that have pending adjustment, or the U or the T, so, or even asylum, right? So one thing that definitely you should always ask is to ask them about all the other status, because usually, because they're using the work authorization for TPS, most people only think about the TPS status. They don't think about all the other status that they have available, because they had acceded the case, or they have put it to the side. So a lot of individual are worried that they cannot go back to work, or they cannot get certain service because their work authorization card is ending. But they tend to forget that you can still reapply for another work authorization based on another pending status that you already had. Specifically, like if you had a pending asylum and just kind of stop using that because they had TPS. So that's something that even non-immigration practitioner don't think about. But if you are rendering service to the migrant community, and you are restricted to the type of individual or the type of studies that they have, to whether or not you can serve them. Maybe a questionnaire would be great as to the different type of studies that you have, because a lot of them will only mention TPS when they have adjustment studies pending with the family member, or a U that's pending for about 10 years and people are eligible for certain grants, or an asylum that's been pending for the past 12 years. So it's also great to ask, do you have any other pending application that have not yet been adjudicated? And then for you to figure out whether or not this person is still eligible for your service.
Right. Thank you for that.
So that's a great point, Deborah, because I was thinking intake wise, a lot of our clients will say TPS, and we might be thinking, oh, that could close the door to eligibility, but that's a great tip. You mentioned going back to the estate planning, we actually hosted a training on estate on POAs and estate planning a while back. I created a materials folder where I've been adding some resources and some links. So I'm gonna make sure that video is in there. We have posted that video on YouTube, so it's actually accessible to anybody. So if you know, this is great for pro bono attorneys that want to learn too. So there is some guidance there on a way that they can help these clients.
No, that is definitely great, because we are seeing the need, definitely, and specifically right now. Because once you are, and I think it's great to mention that if you get detained, depending on how you enter the United States, you might not be able to be eligible for a bond. And we are seeing that very often, especially with TPS holders, right? So if you're not eligible for a bond, there's a lot. If you have a minor child, right, you have a bank account, and there's individuals that have homes where they have the funds. They have the funds to pay the mortgage. They have the funds to pay the taxes in the home for the ones that already finished, but they have nobody to know how to do those things, or they did not let nobody they didn't have no power of attorney to be able to go to the bank account and make those transfers. So definitely, even if they're not eligible for it, I think it's so important to be able to, for your specific service, I think it's important to still be able to advise them of what they should be doing and what they should be thinking of. And if you are, for example, a family attorney, and you maybe you want to do some pro bono work, and when it comes to guardianship, so maybe helping them put it in place, right? And a lot of questions that we get, oh my goodness, okay, so let me do this power of attorney. Well, I don't want to do the power of attorney because I don't want somebody to be able to make decision for me right now if I'm not detained. So, and teaching them and advising individuals that, well, this power of attorney, we could actually have a doable time for it, like in case you get it detained, right? It doesn't have to start today. So I know a lot of TPS holder are reluctant about it because they literally will say, well, I don't want somebody to have power over me or my affairs or my, or my properties or my child while I'm still here and everything is fine, right? So I think the education of telling these individual or even advising them that this could be, you could set a time for those, are also extremely important. So that's something that practitioner can definitely do. And again, that even if you are in a legal service, legal aid, right? But you do have friends and colleagues and the PI world or the criminal world, like these are things that you could also tell them, like, maybe you should learn a little bit about immigration. And I know a lot of PD, even state attorneys that actually call us to ask us about those things just because they don't know how to move around it, because immigration law is different consequences. Even if you're thinking you're doing the best for this individual, it might not be the best for the immigration status in a sense. So it's so important to literally just understand the gist of immigration for you to serve any client that you have that's not a US citizen at this point.
That's such a great point because I think a lot of people forget that immigration affects every part of your life. So, from working to the housing, to financial, to your assets, to your driving, criminal. And so, right now, people are panicking and they're only focused on, do I have a work permit in TPS? But we know we have another issue in the state of Florida of people not renewing their driver's license. And so, a lot of people, their driver's license expired July 1st. And so they do not have an active driver's license, but they still have to go to work. They still have to pick up their children. And that's another consequence of this decision for those individuals. So immigration really does affect many areas. And even though you don't practice immigration, our non-immigration attorneys, there's so much help that you can give, and there's so much that you can do to help because we have these other non-immigration issues that a person has. And so we need a working team of attorneys that are able to help, especially with the estate planning. That's so very important during this time.
Thank you for mentioning that. And so one thing, aside from estate planning, what two other area of law that's being affected greatly right now is housing. Right. So it is a huge issue in the immigrant community, especially a lot of individual that was part of HUD and somehow qualified for HUD. And right now that's a huge issue in the immigrant community and Social Security. A lot of individuals have been working for many years and have built up the Social Security, I guess, the retirement plans, right? So a lot of the retirement plans are at risk. A lot of individuals don't realize that a lot of our county teachers are TPS holders. So a lot of them are retiring and some of them are younger, but their retirement are at risk. We have others that receive Social Security benefits, whether or not it's to a widower spouse or whether it's because of disability, and all of those are at risk. And I'm constantly calling a Social Security attorney for help because hey, my client who's receiving Social Security for his 30 years old spouse, that passed away, and now check haven't come in the past 2 months. What can we do? And they're relying on this to pay for the home, to pay for the mortgage. So, and I've seen it even for the U.S. citizen child because everything is kind of linked together. So, it is so important, like other areas of law that individual don't think about that is currently being affected. What is the best course of action? Maybe to do direct deposit for right now. And, a lot of our elderly, they like to wait for checks, and these checks are not coming because they require some type of status. So what can you do about these? Are you going to lose all those benefits? So those are other things in other areas that I believe a lot of legal services do provide those type of services that could be extremely helpful right now for these individuals that have TPS and is at risk of being ended anytime soon.
Checking the chat to see if there are any other questions. I'm actually making some notes with the estate planning, housing, social security, because we do have some trainings and resources with some of these issues, and if we can help spread the word in any way, and if there are any trainings that we don't have, we definitely will always look into hosting these type of trainings. So there is a question here. Let's see. Any info about legislation change? I guess pending legislation. I think you touched on it a little bit earlier, but I guess somebody
We
asked. So
we
if you're
Yeah, so we right now we have Bill S 4814 that is currently at the Senate level. I of the United States. So we need 62 votes for it to be veto proof, I believe. And that is the goal of the advocates that is behind it right now to extend TPS. We did have a conversation for the chair of Social Security right now, who is congressman. His name escaped me. Billy from Utah. He is the chair of the Social Security Department. And we did brought those issue up to them regarding the Social Security issues and the benefits that individuals are losing. We had conversation with them. Nothing is of it yet, but at least they understand what is going on in the ground, because I don't think many individuals really understood the benefit that others had fought for, and whether or that they're going to lose soon if they currently or not don't have any type of status. So um, that's all we have as far as legislation change in the United States. Nothing in the state of Florida right now.
I'm writing down the you said Bill 4814, Senate Bill.
Yes, S 4814. That's correct.
I'll drop the link in the chat as well. I'm trying to include these in the material so people have
Okay.
access to these.
Well, I mean, I guess, yeah, we can talk about immigration all day, but our time is short. But just I think our biggest scare right now as immigration attorneys and advocate, and what we are seeing is really the children, the USC children's. They are the one that are extremely at risk. We've seen it before where a lot of individuals were removed, and a lot of these children remain in the United States. So I think if parents list in the system, and obviously you guys know that, it caused issues for these children. So definitely, if there was something I would leave you here with today, is if you could just advocate to anyone and who is willing to help. And even if your office can, as far as the pro bono work for and encouraging these individuals, because they're all coming to your office, they're all asking for help. So encouraging them and getting those documents in place for you, for the power of attorney, the wills and trusts, the healthcare surrogate, the nomination of guardianship. So if you could encourage somebody to either learn about it so they can do pro bono work, and if those potential clients all come into your office, even if you cannot serve them, you're able to advise them of what they need to get done at this point. I think that's what I will leave you with.
There was just one more question that just came in. Maybe we have a minute
Okay.
or two to answer it. The question is, what is the status of President Trump's memo to not process relative petitions or green card interviews or halt of citizen oaths for Haitian applicants?
Okay, so I think I'm going to dissect your question really quick, and I'm thinking that you are talking about the ban and the hold that was placed. So there were the 35 country hold and the well, 39 country right now, sorry, 39 country and the 79 country ban. So with the
Mhm.
39 country hold is individuals that are currently in the United States from these 39 countries were not able to get the application adjudicated. So there was a lawsuit, as you always know, there's always advocates ready to fight against those. And we actually got a break about 2 weeks ago, I believe, Anne, if I'm not mistaken. Yes.
Yeah.
So initially there was no application being reviewed for almost a year. And whether it was citizenship application, family relative application, any petitions, they were all being canceled. And now, after the initial part of the lawsuit, we started to have these interviews. But I believe in the past 2 weeks, we have been seeing adjudications. So, which is good news. It is still slow, but we are seeing adjudication with those type of applications. And that was yeah, so right now, it has been lifted in a way. But as far as the 75 countries, is it 75 or 79? 75, I believe, country ban. That's for individual that is outside the United States and cannot request any type of visa or anything again because of national security, because of identification issues. So these individuals, that ban is still on, but the one in the United States is have been lifted, so these applications can actually move forward right now. And
Right.
which is a
So,
great thing too, if I may add, because a lot of individuals were TPS holders and they were waiting to adjudicate their application to either become permanent resident because a lot of them had family, children, or husbands that had petitioned for them or wives that had petitioned for them. Now they are able to adjust the status. So hopefully before anything completely in, but yes, so now these individual can actually adjust their status, the one currently in the United States.
So I think I did already drop the CLE code. I wanted to make sure people have it. I'm also gonna drop a link soon to what I call in the materials folder. In there, you're gonna be able to find the CLE code. I created a Google document where I'm posting some resources that Deborah mentioned that I like, for example, the estate planning one. I added. I also have the Supreme Court order if you wanna. The original order, if you want to read through it. So I know we only have like 3 minutes left, and Deborah, you've given us a lot of information. Immigration is not an easy topic. I don't know how you do it, and I can't imagine how busy you are. I've talked to Anne and Daphne about this topic. I know how busy they are, so I assume you are as busy as they are. So we really appreciate you joining us today and taking your time, to share your expertise with our community. So I'm gonna pass it over back to Anne and to be able to conclude this webinar. But I wanted to make sure that I thanked you. On behalf of the entire legal aid community.
Oh, definitely, it's my pleasure, and it's very heartwarming to hear so many individuals want to understand what is actually going on. Because honestly, it's not only about immigration, as you mentioned, it affects so many different aspects of the law, and us immigration attorney cannot handle it all. So it's always so heartwarming to see other practitioners coming in and say, "How can we help?" And we're like, "Wait, you can't because this is being affected." So thank you for inviting me.
Yes, I echo all of that. Thank you, Deborah. Just a wealth of knowledge. So I'm so glad that you were able to squeeze us in. And thank you again to Jorge for putting this together very quickly at a 3 p.m., not noon. But we knew how important this information was. One, to make sure that you guys had this training and that even if you register, you'll have it later and you'll have some resources of the things that Deborah shared. So thank you again to everyone that joined. I hope you guys got good nuggets from Deborah. Again, you can reach out to any of us if you have any immigration questions. We will. I think I can speak for Deborah. She's always here to answer questions as well. And there's work to be done. So please feel free to reach out if you do want to help, or if you have a colleague that you know they have a heart for pro bono service. We will put them to work. So thank you.
Right. Thank
Thank
you
you.
all. Have a great rest of your day.
All right, bye guys.